Good morning to you, everyone. Good morning. Good morning. Good morning. Good morning from Facebook, YouTube, and Instagram. Good morning to you guys. My name has not changed. Tokunbo Olagbaye. I want to quickly look into near miss cases. Near miss cases is a case that at the time of your submission, you have met the rules requirements, but unfortunately you fail to understand the requirements, or you fail to put in the documents to show that you met the requirement. Of course, obviously it will go against you when it comes to making an application or a decision. The decision maker is not under obligation to remind you to insert a document. And that is the reason why you must at all times consult for advice. Consultation is very important. It goes a long way. And if you are not really a learned person, articulate academically, do not attempt to do the application yourself, because it will cost you more money. It will cost you money and time and stress you. So it is always advisable for you to take legal advice on a near miss cases, because the judges are not under obligation to grant you or to allow your appeal. So even if you're going to show that it interferes with your Article 8 family life right, they don't own you. You will have to go and make a new application for you to now correct yourself where you have made an error. So these cases always happen to people that they think they know it all. Doing the application yourself will not help you at all in any situation, especially when it comes to complex matters. Even students that are filling in the student extension by themselves, many often got it wrong. Many times they get it wrong. So I'm going to give advice this morning rather. I would advise you, both people that are looking at me on Facebook, on YouTube and Instagram, I will advise you correctly that you will need to make sure that when you are putting in an application yourself, unless you know what you are doing, it's not a go area. And if you do put in an application yourself and you are refused and you come to my office, I'm not going to be lenient with you, because you know about my office before you submitted it yourself. Judges are not under obligation at all to do it, to allow your appeal. So in most cases, you will need to show on human rights. On human rights claims, you will have to show that the decision not to allow the documentation you submitted to the judge, you will have to show that the decision is disproportionate and it interferes with your family and private life. If you cannot show that the decision is disproportionate, interferes with family and private life, it's not going anywhere. The judges are not bound. There is no law that bound the judges to accept your documents on an appeal, the document that you were supposed to submit at the time of the initial application. A lot of you are listening to friends. I'm going to encourage you this morning. This is about time you deviate. You deviate from issue of listening to friends. You cannot carry on listening to friends on an application that you know this is your life. If you carry on listening to friends, it will definitely affect you. Thank you, dear. Thank you. Thank you. You too. Thank you. Thank you, Instagram. So you really need to know what you are doing. You cannot carry on saying that, oh, at the time of submission, I met the requirement. If you met the requirement, you will need to submit all the documentation. You have to submit all the documentation at the time of the application. The first tier tribunals are not under obligation, so they are not supposed to allow the appeal if the documents were not available at the time you submitted to the entry clearance to the home office case workers, and possibly on administrative errors. They mistakenly ignore those documents, mistakenly forget to work on those documents, and then they refuse your leave to remain. Then the judge has obligation to look at the document at the time. So if you don't have the documentation at the time of submission, I'm afraid they are not under obligation to accept it. The judges are not. It is often called the meeting the rules near miss cases. Meeting the rules near miss cases. You met the rule at the time of submission on Article 8 family life, but unfortunately, you failed to take into account the documentation that were available. You did not put it there. I have so many clients that are arguing from morning till night and say, oh, I have all the document. Who helped you to prepare the document? Who helped you? Where did you get your advice from? They're trying to save money. And let me warn you again, when you are trying to save money, you will end up paying twice when it comes to appeal. An application to go to the to submit to the Home Office or entry clearance can only cost you possibly few hundreds. But when it comes to going to court, it costs you thousands to go to court. So that is why the rules says that whoever has money get justice done. It's all over the world. If you don't have money to afford lawyer, you cannot get the right justice. Going to court by yourself, especially in the UK, irritates my judges. It does irritate judges. They don't like it. So when you are bringing a child into the country, it is not an application you can do by yourself. Because you have a British passport doesn't mean that you can get your child in Nigeria, in Ghana, in Gambia, in Pakistan, in Uganda, in Jamaica, elsewhere in the world into the United Kingdom just like that. You cannot. You cannot. Because there are certain rules and there are certain complexities in the rules that you have to divulge. You have to pieces to tell the ECO why you think you met the requirement at the time of the application. So I'm not going to take your time. Near miss cases is what I came out to talk about. Near miss cases are cases that the documents are available when you submitted to the ECO, but you didn't include them. You did not include them. You are overconfident. You don't even know what you are doing. Say, for example, on issue of, good morning there, on issue of finance, when you are bringing a wife into the country and you were supposed to meet a certain requirement of salary, 18,600, you didn't show your salary, but off your head you think you have shown your salary, you're not going to go through. You're not going to go through. Or you didn't show evidence of travel or visit to your wife all the time, going in and out. You did not show evidence of responsibility, communication, a lot of things that you need to demonstrate. You failed to demonstrate those things. You're not going to go through. You're not going to go through. That appeal is not going to go through. If you're refused by the entry clearance officer and you are now later on contacting your accountant to be producing SA302, SA100, that is medicine after death. It's medicine after death. But I don't want to give too much away. I don't want to talk too much here. But I just want to remind you, bringing your wife into the country, bringing your husband into the country, bringing your children into the country, you better take advice. If you don't take advice, you are going to waste money. And going to court this time around is stressful, costly, and very daunting. The delay is unnecessary, but it is there as a result of COVID-19 again. So you can easily avoid going to court if you take on a good advice. You can easily avoid going to court. So I'm going to encourage you to contact me on 0208 309 8808. 0208 309 8808. Contact me for all your immigration advice on UK, coming into the United Kingdom, leaving UK, staying in the UK, anything you want to do, applying to remain, applying for extension on the complex cases you want to go to court, contact me. And for those who are fighting on contact order, you want to have access to your children, your husband is denying you, your wife is denying you, and it's a must that you have contact, because without having contact with your children, you will not be able to regularize your status. Contact me. Contact me on 0208 309 8808 for all your contact orders. All contact order, section 8 order to go to court. There is a finest barrister in place that will be handling a contact order from my office for you. A contact order that is a diligent, clever, intelligent, finest, superior person that has a knowledge of contact order, what you need to do, how you have to go about it to have access to your kids, and so that you can use it to make an application to remain in the United Kingdom. My number has not changed. 0208 309 8808. 0208 309 8808. YouTube and Instagram. Stay tuned for now. Until next time, bye.